associate here with the law offices of Melissa Day. Today joining me for this very great episode is Maria Lua, who will be our presenter.
Hi, my name is Maria Lua. I started working at LOMAD in February of this year, and this is going to be my first Lawyers and Friends presentation. And I'm glad to have Neil here as my friend for today's episode.
Oh, thanks. We have to say anything shared here today should not be construed as legal advice directly, but we're happy to be putting on this presentation.
All right, let's get started. So today we're going to be talking about labor market detachment. So we're going to be providing an overview of voluntary removal from the labor market, related concepts, and recent cases pertaining to these issues. So first things first, what is voluntary removal from the labor market? We're going to break it down into three concepts. First, what is labor market? So Neil, think of an actual marketplace where buyers buy goods and sellers sell goods, right?
Okay.
So for our purposes today, replace the term goods with the term labor. So now we're going to have employers or companies which are looking for people who can supply this labor, and then we have people or potential employees looking for employers or companies in need of these labor. So
Right.
This is the marketplace where they meet, interact, and then engage in bargaining for, say, wages, benefits, working conditions, essentially the terms and conditions of employment. So in
Sure.
short, the labor market is a platform in the metaphysical realm where the supply of labor and demand for labor meet. Next, we go to removal. What is removal? So this just means that the person is separated from the market. So he is not working, he's not hired, and there has to be something that happened, an event that transpired,
Okay.
which caused this removal. So either the employee resigned from work, or he got laid off, or he retired, or he got incarcerated, anything that would take him off the market. So he's not in the marketplace that we talked about earlier. He's
Right.
somewhere else, like probably in the library or theater.
Right.
And then the next term is voluntary, and this is the operative word in this entire phrase. So first we have to clarify that voluntary here does not mean voluntariness in the sense of free will or deliberate intent or lack of coercion. Voluntary here means that the removal from the labor market was not related to disability. So conversely, the withdrawal is not going to be considered voluntary when there is evidence that the claimant's disability caused or contributed to the withdrawal.
Okay, so voluntary in this text is a term of art.
Yes.
For sure. Okay.
Mm-hmm. All right, next slide, please. So we're going to discuss voluntary removal in relation to labor market attachment. We always have to remember that these two issues, the issue of requiring ongoing labor market attachment and voluntary withdrawal from the labor market, remain two separate and distinct legal concepts. So again, voluntary withdrawal from the labor market is at issue when an employed claimant with a disability stops working, and the issue becomes whether such withdrawal was voluntary or involuntary, so like we discussed earlier. On the other hand, attachment to the labor market concerns the adequacy of a claimant's attempts to find work within his restrictions. So here we have a person who is not working, and in order to get benefits, he's going to have to try to prove that he's exerting reasonable efforts in order to stay in the labor market. So we get to see this discussion of the distinctions and the cases we cited here. So how are they related? When a claimant's withdrawal from the labor market is found to be voluntary, he would then be required to reattach to the labor market in order to be entitled to further indemnity benefits. So how can you demonstrate labor market attachment? In the case of Matter of American Axle, it's stated that the attachment to the labor market can be demonstrated by credible documentary evidence showing that the claimant is either actively seeking work through an independent job search that is timely, diligent, and persistent, or is actively participating in a job location service, or is actively participating in vocational rehabilitation that is board approved, actively participating in a job retraining program, or is attending an accredited educational institution full-time to pursue employment.
Now, in this case, what we're going to be looking for, these are kind of buzzwords and key terms that we're going to be looking for when we're scrutinizing the credibility of the documentary evidence, right? So for the actively seeking work briefly, in a sense that In May, the judge directed the claimant to begin looking for work. We have the LWEC hearing September, and the claimant just started looking for work last week, right? Of course, that's not going to be timely, and that's going to be our one of our arguments. Diligent, the claimant did a few, but they didn't list the phone numbers, the person they contacted, how they contacted them. That's not being diligent. We're going to scrutinize the persistency. They only applied to one job over the course of 1 month. Actively participating. Now, in the job location, we've had situations where a claimant is really involved in participating. Look, I signed up. That's probably not going to be enough. And in many cases, we've argued that that has been insufficient. So they need to be actively participating, not just having their applications submitted. With the accredited educational institution, here's one where we're going to top of that claimant, because you can say you're going to college and your course list, classes from the registrar, but what about at the end of the semester? Did the person actually go to school? Did they get grades? Are they going to be going to school in the next semester? So just taking all this at face value is something we never would do, and we would scrutinize the sufficiency of this evidence anytime it's submitted. American Axle has been around for a long time, so its progeny is certainly very on point with anything that we would have an issue with.
All right, next slide, please. How about NEO for online job applications? So here, in the case of matter of Suffolk County Health Services, the board acknowledges that an applicant using job websites to search for work typically is not provided with the evidence of an in-person job search that is required by American Axle, as you said. However, many employers and job posting sites that accept applications online provide an email confirmation and or a reference number when an individual uses their site. So if the claimant has been provided these information, then that information should be provided to the board as evidence of job search. And if such documentation is not available, the claimant must at minimum document the date that she made the application, the position applied for, and the name of the site that they used. Okay, so when do we raise the issue of labor market attachment? The first scenario here is we have a temporarily partially disabled claimant who's not working but has the ability to work. Say the doctor said he can return to work with these restrictions, and he's receiving wage replacement benefits. So here we're going to have to raise the issue of labor market attachment. We're going to ask the judge for a directive for the claimant to produce labor market attachment evidence, and then if the judge directs this production of evidence and the claimant fails to produce evidence in compliance with the matter of American Axle, then we're going to get a finding that the claimant is not attached to the labor market, and then what we're going to get is a suspension of indemnity benefits until the claimant is found reattached to the labor market. The next scenario here is when it becomes imminent that the person or the claimant is about to become classified as permanently partially disabled. So if permanency is approaching, then we raise the issue of labor market attachment. We ask for a directive from the judge for the claimant to produce labor market attachment evidence. And then we have to note that this evidence is going to be for scrutiny at the hearing where the claimant is going to be classified PPD. So that's usually called the LWEC hearing, right?
Right.
So if the claimant fails to produce compliant labor market attachment evidence at this hearing, then he will not be entitled to non-scheduled awards until the claimant is found reattached to the labor market. However, Neil, what happens if prior to this PPD classification hearing, the labor market attachment issue was never raised?
Oh, it sounds like it would be a nail in the coffin. But it's not.
It's not the case, because you may still raise the issue of labor market attachment at the time of that hearing. And then we have the case of matter of Elmer's Hospital saying that if the carrier has timely raised the issue of labor market attachment, an LMA determination must be made at the same time as the classification determination. And the board has been unambiguous in its direction that there must be a contemporaneous ruling on the issue of labor market attachment and classification.
Happy days. Not that this would ever happen at our office or the law office of Melissa Day, but if we get a file from another defense firm and they happen to fail to raise labor market attachment at the hearing prior to LWEC, it's good to know we're not sunk regarding that, and we can raise it. And the case would then be, it should be continued for the labor market and LWEC.
That's right. Now let's discuss briefly the issue of reduced earnings in relation to voluntary removal from the labor market. So we got a sample situation here where the claimant got injured at work, and now he's working part-time and earning less than what he used to earn at the time he got injured. So the concept here is, to be entitled to a reduced earning award, the claimant must prove that his disability contributed to the subsequent reduction in earnings. In the case of Zamora, it was held that by finding alternative work consistent with his or her physical limitations, or at least showing reasonable efforts at finding such work, the claimant can prove that the cause of the reduction in income is a disability rather than unwillingness to work again. So here the court said that the claimant must demonstrate that his or her reduced earning capacity is due to the disability. So when it was the claimant's age or general economic factors or something else unrelated to disability which caused the subsequent reduction in earnings, then the claimant is not going to be entitled to compensation. So we can see here that the entitlement to reduced earnings award is essentially a causal relationship issue. So the question is, was the reduction in earnings a result of the disability or by something else? However, next slide, please. Thank you. There have been cases where the board has conflated the issues of causally related reduced earnings and voluntary removal. One such case is the matter of Dorcat Motel. In this case, after being injured from work, the claimant started working part-time and earning less than at injury wages. So here the board panel looked into the reasons why the claimant was only working part-time. It found that the reason for part-time employment was not due to disability, that the claimant's doctors did not limit the number of hours that he could work, that he was not engaged in an independent job search, and he was not exerting sufficient efforts to secure full-time employment. So for these reasons, the board panel found that the claimant voluntarily removed himself from the labor market for failing to seek a full-time employment and therefore not entitled to a reduced earning award. So if we look at this fact pattern now, this would be a causal relationship issue, and applying Zamora, we would have to ascertain whether the claimant's part-time status was causally related to the disability or some other factors such as claimant's mere unwillingness to work full-time. So our takeaway here, Neil, I think is, remember our definition of voluntary removal from earlier?
Absolutely.
That the withdrawal was not caused by the disability. And then we have here Zamora requiring causal relationship between the reduced earnings and the disability, right? So I think our takeaway here is that we can see that the underlying or underneath the defense of voluntary removal is essentially the defense of causal relationship or lack thereof. So are you out of work because of the disability? Are you working part-time now because of disability or because you just don't want to work full-time? So
Sure.
This is all about causation.
That's a good way to boil it down, and not boil it down to simpler terms, but at least a good way to, when you see a case, take a quick look and see, hey, is that causally related?
That's right. Next, please. So now we're going to go to the specific defense of voluntary removal. Again, just to recap, voluntary removal, one is separated from the market, and the removal is due to factors unrelated to disability. And why are we raising this defense in the first place anyway? First, we want to suspend benefits. And if we take it a step further, if we're going to raise it on appeal, then we want the awards previously made erroneously rescinded.
Mm-hmm.
And then we also want to dispute the claimant's entitlement to benefits at the time of PPT classification. So we have here the case of matter of Tully construction, where it was held that if there was a specific ruling that the claimant was voluntarily removed from the labor market or not attached to the market, then the claimant was not entitled to benefits at the time of classification, and the claimant would have to reattach at some point in order for indemnity awards to become payable.
Right, so here it's not a permanent bar on indemnity benefits. This is a short-term solution, but I guess in my experience, and maybe some in your experience, when somebody has their benefits suspended, they usually go to great lengths to rectify whatever the situation is. But at least we get the benefits suspended as at that time.
Okay, So there's this question. Can there be a voluntary removal defense after the claimant is classified PPD? So we're all aware of the 2017 amendment to the workers' compensation law, specifically the one that's basically saying that there's no longer any obligation on the part of the claimant to demonstrate ongoing attachment post-classification if he was found entitled to benefits at the time of classification. And we've also seen several attempts to reopen cases post-PPD based on failure to demonstrate labor market attachment, which have been denied on the ground of the 2017 amendment. We also have the subject number saying exactly the same thing. So one might think, what's the point of raising voluntary removal as an issue post-PPD if the end goal of a voluntary removal finding is to require the claimant to prove attachment again to the labor market, which is what the claimant is no longer obligated to demonstrate in light of this 2017 amendment.
Right.
However, keeping in mind that labor market attachment and voluntary removal are two separate and distinct legal concepts, this abrogation of the obligation to demonstrate labor market attachment does not affect the defense of voluntary removal post-PPD. So we have this case here, matter of woodland leasing. In that case, the claimant was classified PPD, and then he was incarcerated after the classification. There was no evidence that he became attached to the labor market after he was released, and in deciding whether he was entitled to benefits after release, the board looked into whether his incarceration was voluntary removal. And in that case, the board held that the incarceration was properly deemed a voluntary removal from the labor market because it was the claimant's own actions and not his disability that led to his complete separation from the labor market. So there the panel said that the claimant was voluntarily removed from the market upon his conviction, that he remained voluntarily withdrawn as of his release, that he has not reattached to the labor market and therefore precluded from receiving further awards after the release. And the court or the board further held that entitlement to further awards shall be based upon evidence of post-incarceration reattachment to the labor market. I think we're going to be discussing this case again later under incarceration.
I believe so, right.
Next, please. More cases where voluntary removal was considered an issue after PPD classification. So in the case of Matter of Home Care of New York, Inc., the board held that while a claimant who is entitled to benefits at the time of classification is entitled to ongoing benefits without the need to present evidence of labor market attachment, because the claimant was voluntarily removed from the labor market, she must present evidence of reattachment in order to receive ongoing awards. So in this case, the claimant was classified PPD, and then after that classification, she was laid off.
Okay.
We got the same ruling in the case of Society of Sisters of St. Joseph, where the claimant was classified PPD, and then after classification, her job ended because her client passed away and she did not get another job. Then she became ill with an unrelated condition. The board panel found that she was voluntarily removed and required her to present evidence of reattachment in order to receive ongoing awards.
So it's interesting here. So when we're getting ready for ALWEC or even, post-ALWEC, we want to be in contact with our clients to know the status of the claimant.
That's right.
Are they still an employee? But moreover, were they laid off? I mean, we have some employers who are roofers, and you're not roofing in Buffalo in the winter. So we need to know, verify the facts that the claimant was laid off and go from there.
That's correct. Let's treat the facts a bit, Neil. However, let's talk about the application of the 2017 amendment. So we have this question: what if the claimant was found voluntarily removed from the labor market, and because of this, he was found not entitled to benefits at the time of classification, and subsequently reattaches? So after this reattachment, does the claimant get the benefit of 15(3)(w) and would no longer have to demonstrate ongoing labor market attachment, or can we still raise a labor market attachment challenge after? So this is what the law says.
Okay.
What does the statute say?
Well, I think I know what we do here at LOMAD. I think we know the answer is that we're going to go hard on it. It does not alleviate the claimant's obligation. Rather, when they failed to meet the 15(3)(w) at the time of classification, and then they subsequently reattach, we can still poke and prod them
Yes.
and raise the issue of voluntary removal.
Yeah, they don't get the benefit of 15(3)(w). The law is clear. It says claimant who is entitled to benefits at the time of classification. So remember this legal maxim. It says that where the law is clear and unambiguous, there's no room for interpretation, only for application. So just apply what the law says. And then a takeaway here is that let us not waive our defenses. Okay, so let's go into some examples of removal from the labor market and whether they were considered voluntary or involuntary by the court.
Let me do this.
Yeah, okay.
So we have a situation of retirement. In matter of Bruce Supply Corp., the claimant was found to have voluntarily removed himself from the labor market when he retired. On his last day, the claimant indicated that he had just turned 65 and was tired of waking up at 4 a.m. Who wouldn't be? Retirement, in that case, constituted voluntary removal. The claimant didn't mention anything about his disability. His disability had nothing to do with his age, had nothing to do with waking up at 4. It all had to do with him working. We also have matter of Troy and Large City School District. A claimant got injured at work as a maintenance worker, lost more than a year from work, had a separation agreement with the employer allowing him to return to the job in a light duty position to obtain the requisite time to retire with full benefits, and then retired. So the claimant could no longer perform the duties of his maintenance position. Retirement was found involuntary and due to the work injury. His return to light duty position did not mean that the work injury did not contribute to his decision to retire. It was a temporary accommodation so that he could retire without penalty and did not offer long-term light duty work. So, did the work-related disability contribute to the claimant's decision to retire? In the first case, no. In the second case, yes. Even though it seems like maybe no, because he's not saying I couldn't work my job, or, well, I guess that's what he was saying. I couldn't work my job. They gave him another job for light duty that was temporary, allowing him to get the requisite time so that he could retire. So I guess the thing there is that this claimant already had it in his mind that he wanted to retire, the second case. Just like the same in the first case, that claimant also had the idea they were going to retire. The difference is, in the second case, the claimant's return to work in a light duty temporary position was because of the work-related disability.
So this disability contributed to
the decision to retire, right?
Okay, let's go to the next voluntary removal example. So in the matter of New York City Department of Corrections, the claimant had a work injury and then he missed a month of work. He returned to work for more than 5 months and then he resigned in lieu of termination after he was arrested for criminal possession of controlled substance and violation of the employer's sick leave policy. So in this case, the board held that the resignation was found to constitute voluntary removal from the labor market. So we always have to look at what caused the resignation. Did the claimant resign because he could no longer perform the duties of his job? Was it due to disability?
Or did he get arrested and violate the policy?
Yes.
Right. So those are questions that we would be asking our employers and insured so that we would know the answer to that, because the answer to that impacts the outcome of the case.
That's right.
What was the reason that the claimant resigned? We find out that he resigned because the knee, he couldn't walk anymore. That's part of it. There's more to it, but then we would know, at least from the employer, yeah, he resigned because he had, this knee condition or whatever condition. We have a case where the claimant was laid off, and we had touched on that idea earlier. So in Castro, the claimant was laid off due to lack of work since the job for which she was hired was completed. The claimant withheld her name from the union's out of work list, made no attempts to find employment outside of her union restrictions. She applied for and received unemployment insurance benefits. A union representative testified that work had been available for the union members. The appellate division found that her loss of earnings was due to her voluntary withdrawal following her layoff and was not a result of disability. The fact that her doctor found her temporarily totally disabled after she withdrew from the labor market did not compel a different result. So that last piece is also interesting. You have a claimant who was unattached, then let's just say has surgery. Presumably they're going to be a temporary total disability after the surgery. But we'll probably get into that a little bit later too. But when a person is laid off, we need to know the information really that is in this case, right? We need to know from the employer, is the claimant a union worker, let's say? Was the claimant involved with the union with regards to trying to get new work? Like a case, let's say, where the employer still went to the union and had employees working after the completed project, but that person, the injured worker, was not on that list. Why aren't they on that list? So with this and the other ones we've discussed, there's some research in investigation that needs to go on. Next slide.
Next, please. More examples of layoff. So in the case of McGarrigle versus Simpson, although the claimant made an effort to locate work after he was laid off, the job search merely amounted to preparing a resume, submitting the resume to an unspecified number of potential employers at job fairs, and attending one interview. Here, the claimant reasoned that his physical constraints prevented him from doing the job for which he interviewed, but there was no indication that he asked the potential employer to accommodate his disability. He then received Social Security disability benefits, he moved to Florida, and made no further efforts to find a job. Also, his physicians agreed that he's capable of working within certain limitations. Hence, he was found to have voluntarily withdrawn from the labor market after he was laid off. So like I said earlier, Neil, we have to look at the claimant's actions or lack thereof following the layoff. We have to look at the sufficiency of his efforts to be employed after he was laid off, and we can review the restrictions provided by the doctors and when these restrictions were given. Was it given before the withdrawal or after the withdrawal?
Termination for cause. We have three cases here, Caceres versus Lockheed Martin. It's an appellate division case. Claimant was injured at work, only missed 8 intermittent days before he got terminated. He was otherwise able to perform his job with slight restriction on lifting. The employer's manager testified that the claimant performed his job within all medical lifting restrictions and could have continued in that position, but for being terminated for misconduct. Matter of NYC Department of Transportation, claimant was terminated for cause for failure to maintain CDL driver's license. However, the board panel found that his work-related disability contributed to his inability to take the test for the required license and therefore held that the claimant did not voluntarily remove himself from the labor market upon separation from employment. So in that case, yes, the claimant did apparently violate something that allowed him to be terminated for cause. However, that cause was outside of his control in a sense that his disability contributed to the fact that he couldn't get the CDL license, which then contributed to the fact that he couldn't get that. So matter of Walmart DC 6308, claimant was terminated for an alleged safety violation when he threw a pallet too close to a coworker, not for physical limitations that resulted from the work-related injury. Voluntary withdrawal finding was found appropriate in that case. So when we have a termination, our clients certainly will be getting phone calls from us, emails, and getting the information that we need so that we can have the information and plug it in and defend the case.
That's right. Now we have this refusal to accept light duty job. In the matter of Canela, the employer wrote a letter to the claimant after he was cleared for light duty work, vaguely assuring that it provided a safe work environment for its employees, and warning that his job would be in jeopardy if he failed to reach out to plan a new work schedule. Notably absent from the letter, however, is any indication that the employer had a specific position ready for the claimant that was within his medical limitations. So in the absence of any other proof on that point, substantial evidence in the record supported the board's determination that the claimant did not reject an actual offer of suitable work. So here, we have to remember, always look at the actual job duty offer? Was it a genuine offer? Does it meet the claimant's physical restrictions? And we could also send the job duty offer to the claimant's treating physician and ask the doctor for his opinion whether the job description accommodates the claimant's medical condition.
And what's interesting, not interesting, this is a very, I don't want to say specific, but this is a brief overview of what we're doing here, but this is interesting because when an employer offers somebody light duty work, it has to be specific. You can't just say, hey, we have light duty. That's nothing. You have to say we have light duty and your job duties will be X, Y, and Z for this amount of time during the day. Your lifting would probably be between this and this, pulling, pushing, bending, stooping, squatting, sitting, standing, all that stuff. As detailed as possible in a sense so that we could appropriately determine if it was a genuine offer. I'd say the more that we have in there, the more it's going to be a genuine offer. It's going to look like, and presumably it is, a real job offer of light duty to an injured worker as the employer is trying to accommodate.
That's correct.
Sure.
Next, please. However, where a claimant reduces, so for example, the offer was considered genuine.
Okay.
If the claimant refuses the light duty work within her restrictions, the legal standard for voluntary removal is whether the claimant acted in a reasonable and conscientious manner under the circumstances. So in the case of Frosh versus Lakeside Memorial Hospital, the claimant there was a Florida resident. She was employed as a nurse for a hospital here in New York when she injured her shoulder. So in late September, the employer offered her a part-time clerical position, which she could perform within her medical limitations. However, every October, the claimant leaves and spends the winter at her Florida residence.
Nice.
She also has no place to live in New York during the winter, and the employer was aware of these. So citing Okonski, the court found that the claimant was involuntarily removed from the labor market.
Incarceration, like we said, we'd be touching on it again. WCL section 10(4), any person incarcerated upon conviction of a felony shall be deemed ineligible for benefits. All those whose benefits have ceased by operation of this section may apply to the board for benefits upon their release from custody pursuant to regulation with the board. That means a convicted felon, I guess, would fall into this. Ineligible, you have to apply to the board to show that you are not removed. We have matter of woodland leasing. We mentioned this earlier. Claimant was classified PPD, found entitled to continuing payments. Claimant was then convicted of a criminal offense and was incarcerated of felony criminal offense. Insurer suspended benefits. Claimant was released. Should payments be resumed because they were ongoing when he went into jail? No. Section 15(3)W was already in effect. Board panel found that the claimant was relieved of the obligation to demonstrate ongoing labor market attachment. However, the board panel found that the claimant voluntarily removed himself from the labor market since it was his own actions, not his disability, that led to his complete separation from the labor market. Claimant did not make subsequent attempt to search for employment within his medical restrictions. Hence, the board panel found the claimant voluntarily removed from the labor market and had not shown reattachment, therefore not entitled to the resumption of benefits post-incarceration until reattachment.
Yes. So, yeah. Okay, so in that case, the board panel disavowed its decisions in two previous cases, the matter of Thomas and Betts Corporation and the matter of Julio Mateo. So in those disavowed decisions, the board panel, citing the amendment 15(3)W, held that despite claimant's intervening incarceration, claimant was not required to prove labor market attachment to be eligible for benefits. So since these decisions are now disavowed, we don't think that way anymore.
That's right.
Another case of incarceration incarceration is the matter of L. Napieralowski, where the claimant was incarcerated, awaiting charges, and was released 3 months later. His incarceration was deemed voluntary removal from the labor market, and he was required to reattach before his benefits could resume.
All right, we're going to go through some recent appellate division cases as we near the end almost. We have Fuller v. New York City Transit Authority. A claimant was retired. Claim was established for OD to the shoulders, wrists, knees. The judge found the claimant with no permanent partial disability resulting in schedule loss of use to the arm and leg. The issue is whether the claimant is precluded from receiving a scheduled loss of use award based upon his voluntary removal from the labor market effectuated by his retirement. So this is, if you think about everything we've talked about, this is kind of the first time we're talking about scheduled loss of use in this context. The court held that the claimant's lack of attachment to the labor market, voluntary or otherwise, is irrelevant to the determination as to the entitlement of a scheduled loss of use award. Wow. Next slide.
Next slide, please. What's the status of this case, Neil?
Pending appeal, and LOMAD offices has filed an amicus brief. In part, there was no justification for treating two classes of PPD claimants who have withdrawn from the labor market differently. Meaning, it shouldn't matter if you injured your spine or your appendages. The scheduled loss of use award is for presumed loss of earnings, and if that presumption, the scheduled loss of use will cause loss of earnings, is overcome by substantial evidence because the claimant has voluntarily removed himself from the labor market, then the claimant should not be entitled to the scheduled award until they demonstrate attachment to the labor market. The board has been finding that if a claimant has a schedule and non-schedulable permanent partial disability at the time of classification, but has retired or voluntarily removed himself from the labor market, or is not otherwise attached to the labor market prior to classification, then despite the fact that he is entitled to, or excuse me, the fact that he is not entitled to the award for the non-scheduled permanent partial disability, he is not entitled to the scheduled loss of use award.
So those are arguments in the amicus brief.
That's right. And we think that makes sense to me.
That's correct.
Right.
Another case is the case of Hernandez versus AABCO Sheet Metal. Here, the court noted that the issue of voluntary removal due to layoff was raised for the first time on appeal and was therefore not properly before the court. Prior to the appeal, the carrier had been arguing voluntary removal on the ground that the retirement was not related to asbestosis. So here, the ruling regarding layoff in relation to voluntary removal is an obiter dictum in this case and would not really establish any precedent. So the lesson here is when we are raising voluntary removal as a defense, or any defense for that matter, we should use the proper ground. Nevertheless, the court found that the claimant's decision to retire was motivated by his numerous medical conditions, including those resulting from his work-related asbestosis. His withdrawal from the labor market was found involuntary.
All right. Well, in this next case, Ryan v. City of Albany, the claimant was found temporary partial disabled and directed to produce labor market attachment evidence. Claimant didn't produce the labor market attachment evidence at the next hearing, but instead offered a medical report indicating he was temporarily totally disabled due to an unestablished right hip injury. Have we not seen that? Claimant was found voluntarily removed from the labor market. Benefits were suspended. That finding specifically was not appealed. Now, 2 months after, claimant filed another request for further action, wanting to revisit the issue of labor market attachment. At the requested hearing, I can't believe this still.
I don't know why he didn't.
The claimant still didn't submit any labor market attachment evidence. The request to revisit labor market attachment was denied. That was appealed, right? And then the board affirmed the worker compensation law's decision, and it went even further to the Court of Appeals, which affirmed the medical opinion finding the claimant temporarily totally disabled did not alleviate the claimant from presenting labor market attachment evidence at the time of the hearing as directed by the judge. It was rendered after he was found temporary partial disabled and after he was directed to produce labor market attachment. Also, the executive order declaring the state of emergency and suspending labor market attachment proof was found inapplicable since the claimant's benefits were already suspended at the time. Hence, claimant was not entitled to further benefits as he remained unattached to the labor market.
All right. In this next case, the case of Blanche versus Delta Airlines, the claimant provided no proof that she was attached to the labor market. She was unable to recall the name of anyone from the carrier that she spoke to about light-duty work and whether such conversation even took place. The claimant's testimony was found by the court to be wholly incredible, and she was found voluntarily removed from the labor market. Also, this case reiterated the ruling in the case of Bruno, which says that the appropriate date of a finding of no labor market attachment is not the date that the issue is raised, but rather the date that the evidence of showing a lack of labor market attachment was submitted. So we have a tip here. Credibility of the witness matters. So here the claimant was trying to prove that she was attached through the labor market through her testimony, and since that was found to be incredible, then she lost it.
Wow.
Mm-hmm.
We have Joseph v. Historic Hudson Valley. A claimant was injured, returned to work light duty, laid off for reasons unrelated to the injury, was later found temporary partial disabled. The judge found labor market attachment, but the board found that there was no attachment and rescinded the benefits. The board held that the board, I'm so used to saying that. The appellate division, although the claimant prepared an extensive chronicle of her meetings and phone calls with these job programs, there's little supporting documentary evidence as to the extent of her participation with them. Moreover, claimant admitted that she had not enrolled in any vocational training and had not applied for any job within her medical restrictions. Since she stopped working in 2018, claimant did not demonstrate an active participation with the job location service or that she was engaged with a diligent, persistent, independent job search within her restrictions as to maintain an attachment. Here, look at the extent of the claimant's participation with the job programs, look at whether the claimant applied for jobs that they could actually perform given her restrictions briefly. That goes back to what I said earlier. You can apply to work with Access VR, but if you're not involved with them, that's not enough. If you have a construction worker that is applying for a job as chief of surgeon, okay, I'm just going to go ahead and say, without the claimant's testimony, that they can't actually perform that job. I know that's a little extreme, but that doesn't have to do with the medical restrictions, but that also applies to medical restrictions. I mean, let's say you have a light duty work and a lifting restriction of no greater than 5 pounds, yet this person's applying to a roofing company or construction. I mean, that is going to require more than 5 pounds. That is not a reasonable expectation that the person would get the job given their medical restrictions. Next slide.
We have the case of Gambardella versus NYCTA. Here, the claimant sustained schedulable and non-schedulable injuries. And then at permanency, he was found ineligible to receive non-scheduled awards since he voluntarily retired in 2020 and therefore not attached to the labor market at the time of classification. However, he was found entitled to scheduled loss of use awards. And in this case, referencing Tahar and Aris, the court held that as no initial award was made based upon the claimant's non-scheduled PPD classification, he is entitled to an SLU award for the permanent partial impairments to his statutorily enumerated body parts. The court stated that the salient condition for a claimant to receive an SLU award where he or she has both scheduled and non-scheduled impairments arising out of the same accident is the fact that he or she is ineligible to receive a non-scheduled award at the time of classification, whether that be due to his or her return to work at pre-injury wages or here voluntary retirement. And citing Fuller, the court stated that a claimant's lack of attachment to the labor market, voluntary or otherwise, is irrelevant to a determination as to entitlement to an SLU award. We don't like this case.
Okay, good. Board panel. So now I can be right when I say that. A matter of Montefiore Medical Center. IME report found MMI dated 10/12/20. Labor market attachment raised on 10/1/21. Claimant was directed to produce labor market attachment evidence within 60 days, i.e. 12/5/21. At the LWEC hearing on 1/7/22, claimant conceded there was no evidence of labor market attachment. The judge found the claimant unattached as of 1/7/2022 and not entitled to wage loss benefits. Carrier contended that the claimant should be found unattached as of 10/12/20, which is the date of the independent medical examination. Citing Blanche, the date of finding of voluntary removal is not the date the issue is raised, but the date evidence showing lack of labor market attachment submitted. Here, 12/5/21 was the date such evidence was due, but none was submitted. Therefore, the board panel held that the proper date finding no attachment was 12/5/21, not 1/7/22. And really, that matters. Let's say awards were ongoing. That's a month's worth of benefits.
That's right. In the case of matter of Western New York DDSO, the claim was established for the neck, back, and left shoulder. The claimant retired in 2017. In 2021, the claimant was classified PPD. The law judge found that since there was no evidence that the retirement was due to injuries, the claimant was no longer attached to the labor market following her retirement and not entitled to lost wage awards or SLU awards. So we can see here that the law judge is on our side. But
Yeah,
the
all
issue
right.
here is whether the claimant is precluded from receiving an SLU award. And the board here stated that based on the court's decision in Gambardella, the board panel found the claimant is not precluded from receiving an SLU award. So yeah.
We could see, I guess I could see that coming. So the law judge agreed with our position, but the board panel has yet to.
Because they have something to cite now.
Right, they can hang their hat on it.
Okay.
Next slide. Matter of Office of Children and Family. This case also cites Gambardella and Fuller. 2016 claim established neck right shoulder. Claimant had a prior right shoulder claim or right arm claim in 2020. The claimant was found voluntarily removed when he stopped work in 2018 due to unrelated non-compensable condition. Thereafter, the claimant was classified in 2022, found not entitled to the PPD award, therefore was entitled to the scheduled loss of use award for the right arm, offset by the scheduled loss of use award in the prior case. The issue is whether the claimant was entitled to the schedule after he was found to have been voluntarily removed from the labor market. Boo. Consistent with Gambardella, claimant's entitlement to scheduled loss of use is unaffected by any finding on labor market attachment. The fact that the claimant voluntarily retired and therefore was not attached to the labor market does not preclude him from receiving a scheduled loss of use award, because it is axiomatic that claimant's lack of attachment to the labor market, voluntary or otherwise, is irrelevant to the determination as entitlement to a scheduled loss of use award.
Okay.
Yeah.
And then this case, a matter of Trinity Packaging Corporation. Here, the claimant was found detached from the labor market, benefits were suspended, the claimant reattached, and then benefits resumed. The claimant was then found PPD and was paid an SLU award in 2020. In 2021, the claimant underwent surgery, which made him temporarily totally disabled, and now he's seeking post-surgery awards. So the issue here is whether the claimant was entitled to indemnity benefits for lost time following her surgery. The board panel said, generally, the board may not deny benefits based on a finding of voluntary removal if the claimant's overall total disability is due, at least in part, to the work-related injury. However, stating the case of Baki, once the board finds voluntary removal, the claimant was reattached before there is a finding of subsequent causally related lost earnings. So here the board panel noted that the claimant did not return to work. He was not working before the surgery, therefore there can be no reasonable expectation of wages or wage replacement benefits for the periods of alleged temporary disability after the SLU was implemented. So the board panel affirmed the law judge's finding that as the claimant has not returned to the workforce or reattached to the labor market between the time of the SLU award and the time of the subsequent surgery, she had no wages to lose, and as a result of the surgery, and was not entitled to indemnity benefits. So here the court cited in passing the case of Fuller, the one that said that entitlement to SLU award is unaffected by one's attachment to the labor market. But I don't think that was necessary, because here we're not talking about whether she was entitled to SLU. She was asking for lost time benefits.
Interesting.
Yes. So I think that concludes our presentation.
Hey. Well, on behalf of the law offices of Melissa Day, myself, and Maria, we want to thank you for joining us on this episode of LOMADtv. I guess if there's any questions, I don't know if there are, we're good to go.
Yeah.
All right. If anybody wants a copy of the presentation, I guess, just email hearings. We're probably pretty good about that. And otherwise, give LOMAD a call.
Thank you, everyone. Have a great one.